Welcome to the Wealthy Life Podcast. I'm Sybil Verch, and today we're going to be talking about wills, why you need one, what to include in it, where to get it done, how much it costs, and so much more. Joining me today is Erin Bury, CEO of Willful. Her and her husband are revolutionizing the way wills are written and done. They're making it so much easier. They've appeared on Dragon's Den and have been featured in the Globe and Mail and CBC. Erin, welcome to the podcast.
Thank you so much for having me, Sybil.
So Erin, what does living a wealthy life mean to you?
Great question. For me, wealth equals time freedom, an idea that I read about in The Psychology of Money. So the idea is that true wealth is waking up in the morning and having the freedom to do what you want with whom you choose. Money is a conduit to get that freedom, but it's not the only means to it. And so I think I'll be truly wealthy when I have that autonomy over my time.
Oh, that's beautiful. Well said. You'll control your own calendar and you'll be wealthy.
Exactly.
So what do people need to know about wills? Let's start at the beginning with, what is a will?
A will is a high-level legal document that dictates a few things when you pass away. It appoints an executor to handle your estate and wrap things up after you die. It appoints beneficiaries who receive your assets or any special gifts. And if you have minor children or pets, you can also appoint a guardian for their care. What it's not is a detailed look at your assets or your net worth. It's really a high-level document that takes into account anything you own at the time you pass and only comes into effect when you pass away versus power of attorney documents, which come into effect while you're still alive, but need someone to make decisions for you.
Yeah, and a lot of people get confused on those two things because the power of attorney has control while you're still alive, but as soon as you're dead, the power of attorney ceases to exist. That power is no longer valid, and the executor steps in and decides, reads your will and distributes the assets as per your wishes.
Exactly. And that's really the key to having a will, right? If you don't, then a government formula in your province dictates who gets your assets. The courts have to appoint an executor to wrap things up or guardians for young kids. And so it really is important to dictate your wishes and to make sure your family knows about them.
Well, yeah, nobody wants the government making decisions for them. At least I don't think they do. So get a will in order. But most Canadians don't have a will, or at least half Canadians, I think, don't have a will. Why do you think that is?
Yeah, about 57% of Canadians don't have a will, and 1 in 10 have a will that is out of date because they created it 10, 20 years ago and their life looks very different today. I think there are a few reasons people don't have wills. The first is obviously that it's uncomfortable to think about, right? We as a society do pretty much anything we can to avoid thinking about our own mortality. And in some cultures, some folks believe that if you do think about it, it will somehow hasten it or bring it upon you. And then I think just a lot of logistical barriers, right? I think, and a lot of unknowns. People don't know how much it costs, how long it takes to get it done. So there's assumptions made that it takes a long time, that it involves getting all my paperwork and my financial statements and my taxes, and that you have to use a lawyer and it's going to cost me thousands of dollars. And it's also just one of those things that doesn't have a sense of urgency to it. No one calls you and says, hey, Sybil, you're going to die on May 17th, 2002. No, you have no idea. And so it's something that, like clean the basement, tends to linger on the to-do list, and there isn't always a sense of urgency to get it done. So we avoid thinking about it. We don't always have the information we need to empower us to get it done, and it feels not urgent. And those things combined lead to a lot of inaction.
So how do we make it easier? How do we motivate and inspire Canadians to just get it done?
Well, I don't think the will is unique. There are other things like life insurance that have the same kind of adoption rates or even less. And ultimately, it is asking you to do something that will never benefit you, right? If I take out a life insurance policy, by definition, I have to die for my family to get that money. And the same is true of a will. I'm putting wishes into place that will only come into effect when I die. So it really is something that is selfless to do. It's something that is setting up your family, that is reducing burden on them. But, if you asked any mother, or parent, would you do anything you could to make your kids' lives easier? I think the answer is yes. And this is one that is very low effort, but hugely high impact. And anyone who's been an executor, whether the person had a will or not, knows how much work it is, even when you're very well prepared. So I think it's partly just education. I always say at Willful, we're not selling wills. We're selling education to get you to the point where you believe you should have a will and you should do it now, because that's the biggest gap that exists, is that intent.
And your family will thank you. You may not benefit because you'll be dead, but your family wants it easy. And without that, it's going to make it hard. It's already an emotional time. It's stressful. It's going to cost more money. And the other thing is, maybe more money will go to the government than you originally intended. And that might be a motivator for some to peel that back a little bit.
Hopefully. Yeah, it's one of those things where, this podcast is all about creating a wealthy life. And we spend so much time thinking about how to grow our net worth, how to invest wisely, how to prepare for the future. And we spend almost zero time thinking about how to pass on that legacy, that wealth effectively to the next generation. But to your point, with some strategic planning, you can ensure more of that wealth ends up in your family's hands versus to the government or people that you didn't intend.
So I should have asked you this at the beginning, but I'm going to ask it now. How did you get into this in the first place? What inspired you to tackle wills?
Well, you might think that I'm an estate lawyer, but I'm not. My husband and I founded the company because we were people that were in our early 30s who needed a will and who were quoted over $1,000 to get it done, who were being asked to take time off work to go sit in a lawyer's office, which felt very intimidating. It was really inspired by the loss of my husband Kevin's uncle. He died and had a will, but he had never discussed the pieces outside of that: funeral and burial wishes, where important paperwork was stored. So ultimately, Willful's mission is to ensure every Canadian adult has a will, but also to help us have the conversations about those other things. Where is the paperwork stored? What assets do you own? And how can your executor find them easily? How do you want to be celebrated? A funeral, traditional one, or a celebration of life? Mine would be open bar with pizza. So that was really the idea, is that we do so many things online, and yet estate planning is still expensive, paper-based, appointments in lawyers' offices. And it was one of those, there has to be a better way. And we built the company that we wanted to use and then partnered with estate lawyers to bring it to life.
Oh, that's incredible. So walk us through the process of Willful. What would somebody experience?
So it's very similar to the process that you would use if you visited a lawyer to create your will, except digital instead of kind of over the phone or in person. So typically when you visit a lawyer, they're first going to start by understanding more about your situation. Are you married or single? Are you in a blended family or not? Do you have children? And if so, are they minor children? And so that's what we do on Willful. It's a completely self-guided process where we start by asking you about your family. And then, like a lawyer would do, we get into, okay, who do you want to appoint in key roles? Who do you want to be your executor to wrap things up? Who do you want to be a backup in case they can't do it? We allow you to leave any special gifts to people, like a musical instrument, a piece of art, or a cash gift, and then to divide up your estate by percentage. And then if you have minor children or pets, you can appoint a guardian for their care and even leave a cash gift to anyone who might be caring for your pets because, of course, they're expensive. So that entire process is self-guided, much like tax software. Mm-hmm. And then we give you a PDF document that in 9 out of 10 provinces, everywhere except BC, has to be printed, signed, and witnessed on paper. In BC, we have a digital signing service, so you can electronically sign and witness the document and store it as an electronic copy.
Now, what about the person who wants to write a will themselves, just pen and paper, type it out? What can go wrong? What can go right? It sounds like you've got a nice guided process, online, electronic. You don't have to go to the lawyer's office. But walk us through some of the mistakes that happen.
Yeah, I think if you, on the cheap, free side of things, you've got handwritten wills, which are legal in most provinces and are the only type of will that don't require a witness to sign it. So you can write it in your own handwriting. You can't type it out on the computer. It has to be in your own handwriting and signed by you. And then on the other end of the spectrum, you have lawyer drafted wills, which are typically the most expensive, but also the most customized And they have the ability to include a lot more than something like Willful, which only accommodates, certain situations and doesn't have a ton of complexity. I think the biggest challenge with handwritten wills, and listen, if your budget is zero, it's free, it's still a better option than having no will at all. But the challenge is, if I think back to 10 years ago before I founded Willful, I wouldn't have known what to write and I would have left things out. I might have said, I want everything to go to my husband, Kevin, or my boyfriend at the time. But I probably wouldn't have known to appoint an executor or a backup if in case that executor couldn't do it. I may not have thought about, any special gifts that I'd want to leave. And wills typically have a lot of language, powers that executors have, and instructions that you just wouldn't know if you weren't in estate planning. Here's an example. I have 2 young daughters, and if I passed away without a will, my husband would get some of my assets, and my kids would get the rest, and they'd be held in trust until they turn 18. At which point they'd be given to them in a lump sum. So in my will, I can dictate, hey, I don't want them to get a lump sum at 18. I would not have been responsible with that. Give them half at 21 and half at 25. That may not be something that you're thinking about if you're writing a handwritten will. So common mistakes would just be omitting things. And then there are also a lot of will kits that you might buy at a store like Staples that are kind of fill in the blank style. The challenge with these is there's a lot of execution errors. People aren't signing and witnessing them properly, and they only, they're very standard one size fits all, versus a platform like Willful, which if you have young kids is going to ask you a bunch of questions that you won't get if you don't have young kids.
It's nice having the guided approach or a professional if that's the situation, rather than trying to figure it out yourself. So that's very helpful. What are the main things that need to be included in the will? What are the things that people need to gather in advance to go through the process?
Great question. So, really a will is 3 key decisions. Who's going to be my executor to wrap up my estate, and who's going to be a backup in case they can't do it, who's going to get my assets and in what split, and who's going to care for any minor children or pets. If you don't have pets, great. You don't have to worry about that. If you don't have minor children, great. You only have 2 decisions. You don't really need to gather, financial statements, tax returns, anything like that. Your will is not a listing of all your assets and liabilities. We actually have a separate estate inventory document on Willful where you can say, here's where I bank, here are my properties, here's my car, here's everything the executor would need to deal with when I pass away. The will typically does not include a listing of that because your assets change all the time and you wouldn't want to have to update your will every time you got a new car or moved to a new house.
But they should have that list somewhere because otherwise
Yes.
the executor is going to have a very difficult job of finding where all the assets are.
Absolutely. Otherwise, it's a bit of a wild goose chase. And the executor, waiting for physical mail to come in, tracking email, if they have access to your email accounts. And so it's already a hard enough job to be an executor. The more information you can give them, the better. And so that's why we have that estate inventory document where you can list out assets and liabilities, leave notes to the executor, but it's not contained in your will. So really to sit down to write your will, you just have to think, who do I want in these key roles? And we can probably guess based on your life situation who you're going to appoint. For example, I'm married with young kids. 70% of our customers on Willful are like me. They're married with kids. And so I bet you any money that most people are appointing their spouse as the executor. For the backup executor, they're probably putting a parent or a sibling if they have them. They're leaving everything to their spouse. And then if the spouse dies at the same time, both of you die at the same time, then they're splitting between the kids. If one of the kids dies, they're leaving it to grandkids if they have them. And so, based on your life situation, we're working on an improvement to Willful where we actually say, this is what most people in your situation do to help actually guide those decisions. But most people, if I said, who would you want to wrap things up for you? Someone you trust, someone who has knowledge of your situation with the capacity, they're usually naming a spouse, a parent, depending on their age, a sibling, a close friend. And usually the executor is someone who may also be a beneficiary. For example, my husband, Kevin, will be my executor, but he's also going to be the beneficiary of the estate. And that's very typical too.
Now, what are your thoughts on asking the executor if they want the role?
I'm a big fan of always over communicating about these things. Just because you appoint an executor in your will doesn't mean they have to actually do it. So for example, if I found out my neighbor put me in as the executor, I'm probably going to say no. I have a really busy business. I have 2 toddlers. I don't have time for that. It's hundreds of hours of work. And so asking someone in advance, whether it's to be the guardian of your kids or to be the executor, is a nice thing to do just to make sure there's that initial yes. It doesn't mean that when the time comes, years down the road, that they still might be open to it or take on that role, and they can still decline it. So that's why it's so important to have that backup layer. The one role that you don't need to discuss with anybody is who you're leaving your assets to, right? And this is what I hear a lot from folks, especially who have aging parents. They say, I really want to bring this up with my parents because I want to make sure they have a will. If they die without a will, I know I'm going to be the one dealing with it. It's going to be this huge mess, but I don't want to bring it up as if I'm asking about my inheritance. And asking if your parents have a will and if they have documented those things is very different from saying, hey, mom, dad, how much money am I going to get? And it's true. I have such a vested interest in making sure my parents have their estate plans because otherwise I'm going to be cleaning up the mess.
Yeah, we've got a planning document on the wealthylife.com that we encourage everyone to complete and that their executor knows where to find it. It sounds like you've got something similar on Willful, so that it just makes the process that much easier, especially if you're not having that conversation in advance, don't feel comfortable. At some point, all of that information is going to come out. So just make sure it's organized. So on the executor piece, what about people who don't have someone that they want to appoint and choose to appoint a corporate executor? How does that work, and can Willful accommodate those situations, or is that when a lawyer is needed?
So most people appoint an individual executor, a spouse, a family member, a friend, but it is a big job to be executor. And a lot of people either don't have someone that would naturally fit in that role, or they know that they don't want to put that burden on a loved one, which is when a corporate executor can step in. This is typically a professional executor firm, a trust company, or the trust division of a bank, for example, Scotia Trust at Scotiabank. And right now, Willful does not cater to this. We only cater to appointing individuals, although it's something that we are looking at. The reason being that this is a really personal engagement with the trust company. Everyone has a different compensation agreement. Usually there's language that's added to the will based on the corporate executor. And also because corporate executors usually have really strict guidelines about who they will and won't work with. The reality is these are businesses that make money. And for them, they have to judge, is this person going to make us money? Because they take fees based on usually the size of the estate. And so, it can get a bit complicated if you don't speak to them first, because they might actually turn it down when the time comes. So usually if you want to work with a corporate executor, you would want to speak with them first, and you would sign an agreement with them saying that they are going to take this on and outlining their fees and any stipulations. And then typically your will would reference that. And so right now that's something that can be done with a lawyer or professional, but that we're looking to add in the future.
Great. So if someone appoints a family or a friend, do they put the fees that that family or friend can charge in the will? Is that a good idea? What happens if they don't? Does that person get paid?
Great question. So all executors are entitled to compensation, and there is provincial legislation outlining how much they are entitled to take. If you want them to receive no compensation, you can put that in your will. If you want them to receive more compensation than is outlined in that legislation, you can put it in your will. Our wills do not include an executor compensation clause because it's outlined in the legislation, and the courts are going to rule on that anyways. And typically it's based on two factors. Number one, what is the complexity of the estate? Is it just money sitting in a bank account, or are there tons of accounts and a lot of work and complexity and investments versus liquid cash and properties? And then second of all, how much effort does the executor put in? Did they hire a lawyer, an accountant, a consultant who did everything for them and they just directed them, and that cost the estate a lot of money? Or did they do everything themselves, or a lot of it themselves? Those are the factors that go into how much compensation someone will earn. For me, I wouldn't want to deviate from the standard because I think the legislation exists for a reason. But if you do want to give more or less, just a caution that if you give nothing, an executor might say, no thanks. This is a lot of work and it's already pretty thankless. So the compensation is there for a reason, because this is work to be an executor.
Yeah, and you just want to be fair at the end of the day. So it sounds like the guidelines are in place for that. How do you deal with black sheep of the family, or unfair, what may be deemed unfair distributions, can it be challenged? Is there anything you can do to protect yourself in that case?
Great question. So any will can be challenged. If I have a disgruntled relative that thinks they should have had a share of the estate, they can challenge it in court, but the onus is on the person or people challenging it to provide evidence to the contrary. So, if my cousin Joe wanted to go to court and say, Erin promised me $1 million, great. Do you have a recording of that conversation? Do you have it in writing? Is there any evidence of the will maker's intention? If not, we're going to go with the will because that is a legal, recording of the will maker's wishes. However, if you know that there's contention in the family, if you know that there's likely to be a challenge because you just have a relative that is like that, or you've had a falling out, or to your point, you are giving disproportionately more to one person versus another, you can state and include that in your will. You can include a disinheritance clause. I don't want cousin Joe to get anything because he was a jerk to me my whole life. Sorry, cousin Joe. Or you can include, an explanation. I even heard of a woman who didn't have children. She had nieces and nephews, and she included a clause saying all of her nieces and nephews would split the estate, sizable estate, equally if they came to the funeral, and only a couple of them did. So these are situations where you may want to visit a lawyer, because when you work with a lawyer, you get customized legal advice to your situation. Willful's not giving you legal advice. We're guiding you through the process. You're essentially creating your own legal documents based on templates written by estate lawyers in your province, but you're not getting the advice of, hey, Sybil, you don't like cousin Joe, here's what we're gonna do. And lawyers also record notes. So they can, once you've passed away, go back to those notes. And if they had to in court, say, oh, I remember this conversation. I made a note that Sybil was very clear cousin Joe should get nothing, and here's why. She gave me these 3 bullet points. So if it were me and I knew there was likely to be a lot of contention around my estate, I would likely work with a lawyer to make sure they had that documentation and supporting notes, and I would include it clearly in my will. But even if you don't have contention in your family, as you know, estates often become contentious. And so the best way to avoid that is being very clear with what you do want in your will. And if you have any supporting phrasing that you want to write down and store as a letter to the executor, you can always do that. It's just not part of the legal document.
Yeah, we encourage that. We also encourage some estate planning in advance from a tax saving strategy perspective as well. And people may want to include charities. Is that something that is included on your platform?
It is, and we are very passionate about legacy giving and directing more legacy gifts to charities. To your point, I think there's a lot of many misconceptions about what's actually covered by your will. So that's a great reminder too. I own the house I'm sitting in jointly with my husband. We have a joint bank account. If I were to pass away tomorrow, the house would just be his. It's not like it would pass through my will. So there are some assets that are covered by your will, mostly solely owned assets, and anything joint or anything that has a registered beneficiary, registered accounts with a beneficiary or a life insurance policy that names an individual, those things are not going to flow through your will. So to your point, a lot of people may create a will, but they can also visit a tax specialist to say, how do we control what is actually covered by the will, and use things like trusts in complex situations to bypass, capital gains taxes that would be owing, et cetera, which I am not a tax expert. So that is definitely a speak to an expert.
Well, you're talking about the complications that can come up if distributions aren't fair, the challenges that may arise. Could you imagine how much more complicated it would be if you didn't even have a will in the first place?
Yes.
So
absolutely. And I mean, listen, you only have a legal obligation to support a legal spouse and financially dependent children. There was a case a couple of years ago of the Scholastic CEO who's from Toronto. He passed away and he left all of his estate to his girlfriend, who was also an exec at Scholastic. His ex-wife and his adult children were not pleased, but they're financially independent. They didn't rely on him, and his ex-wife is his ex-wife. She's not currently married to her, and so they didn't really have a legal leg to stand on. So it is a good reminder, again, you don't have to discuss how you're leaving things with the people you're leaving them to, but you do, if you have a legal spouse and financially dependent children, have an obligation to support them.
And how often should your will be reviewed and updated?
Well, I would love to see people review their will every year at tax time. Nobody wants to do their taxes. Nobody wants to think about death. Let's just pair them together and review all of those details at the same time. So realistically, every year is great. Every 2-3 years, you're likely going to have something change in your life. Someone named in the will might pass away. For example, if I list a parent as an executor and they're aging, there's a chance that in the next 5, 10, 15 years, they might pass away. Maybe I named a friend to receive a gift or act as my executor, and we had a falling out. Or I got married, had children, got divorced, and there's a reason to either put someone in or take someone out. So maybe even moving provinces, right? There are so many things that could cause you to update your will, but even just reviewing it and saying, yep, still makes sense, at least it means it's up to date.
Now, you talked earlier about going to the lawyer and getting a standard will may cost $1,000. Obviously, more complex situations can go up from there. What are people looking at on your platform?
So on Willful, it's $129 for just a will and $199 for a will and both power of attorney documents, one for finance and one for medical wishes. And that includes free updates. So as your life changes, you can come back and update your will without having to pay a lawyer's hourly fee. However, we are a complement to lawyers. We know that our ultimate goal is making sure every Canadian has a will, and we're going to be able to help lots of folks, but there are lots of folks that need a lawyer. So, based on your budget, your complexity, your situation, a lawyer is an awesome option if you have the budget, and if you really want that tailored legal advice or have any complexity. Willful is also just a great place to start to go through the process, right? Just to get a sense of what questions am I being asked? What decisions do I have to make? We have a Learn Center that's chock full of great articles, all of which are reviewed by lawyers and experts. So it can be a great place to start, even if you ultimately choose to work with a professional.
And how long should people allow? Like, what's the time commitment on a standard, simple situation?
Well, our marketing tagline is create your will in under 20 minutes, and that is not an exaggeration. You could, if you knew the choices that you wanted, you could create your will in 10, 15 minutes. You'd still have to print it, get it signed to make it legal, but you can truly, because again, it's really some high-level decisions. It's not 35 questions. It's not like a life insurance application where you have to tell me if you've skydived in the last 5 years or smoked a cigarette or your family's health history. No, it is really just tell me a little bit about your family, appoint these 3 key roles. Often those are the same people. So it's really the knowing who you want to appoint that is the time-consuming part.
Wow.
We often have folks that get stuck halfway through, especially parents of young children, because they get faced with that question, who would care for your kids if you and the other parent were not around? And then they get emotionally paralyzed or they argue, right? My sister versus your brother. So that's really the key, is deciding on who you want to put in those key roles. The actual creation on Willful is 10, 15 minutes.
That's incredible. So those people who are thinking time and money were the obstacles of getting it done, you've eliminated that problem. Like, it's super easy and it's very inexpensive. So is there anything I haven't yet asked you that I should have?
Oh my goodness. Well, I think we touched on power of attorney documents, but I think these are really important in just explaining what they are. A power of attorney document appoints someone who is going to make financial or medical decisions on your behalf if you're incapacitated. And so, if I were in a coma, it gives someone the legal authority to make decisions for my healthcare, as well as to do things like pay bills or shut down credit cards or apply for government benefits. So these are, most people on Willful are choosing the packages that come with the power of attorney documents, and they're much easier to create than a will. The financial one is just, who do you want to make financial decisions for you? And these are often the same person you're appointing as executor. For example, I've said my husband, Kevin, he's my attorney in my power of attorney documents, and he's my executor. So it often isn't really hard to think of who you would appoint in that role. You've already done that thinking about who would be the executor.
Well, every single Canadian of legal age should have a will, a power of attorney, and a representation agreement for medical. So I fully agree with that. Sounds like the package is all there, making it super easy for Canadians. I can see why you're starting to see some great success in this, and I would love to see the numbers move. I want to get away from that 57% you said don't have a will. Let's say if we can get that down to zero. Make everyone have a
You're
will.
helping to spread the word. So we appreciate you and the work that you're doing on the Wealthy Life podcast.
It's an important part of people's wealth and their life. Erin, thank you so much for being with us today. It's been a pleasure.
Thanks so much for having me, Sybil.
And thank you to our audience. We appreciate you, your likes, your follows, your shares. What would you like us to cover next? Let us know. Reach out to us at thewealthylife.com. As always, please seek independent professional advice before taking action. We are here to provide information to help you learn and ask the right questions to make smart decisions so you can live the wealthy life.